Ladies and gentlemen, we are very glad to start this panel on online behavioral advertising. My name is Tanguy van Overstraeten. I'm sorry because we should have as a chair Karim Lesina from AT&T, but he had to inform us that he was invited to go to Davos, in fact, this week. So I can imagine that maybe that's something that you cannot refuse. And therefore, well, I will be your ad hoc chair for today. Before I make an introduction on the topic itself, I would like to present all the panelists. And I will start from my right-hand side. Walter van Holst is an invited expert to the World Wide Web Consortium, the Do Not Track Working Group. He is also a volunteer with Vrijschrift, which is a Dutch NGO in the field of freedom of expression, free software and IPR reform. And he is also an IT legal consultant focusing on procurement issues. Anna Buchta, is it Buchta or Buchta? Buchta, thank you, is the head of litigation and legislative policy of the EDPS in Brussels. Before joining the EDPS, she worked for various European Commission Parliament dealing with data privacy, information security in relation to the electronic communications. I have then Kenneth Parnham. Kenneth Parnham is the managing director for the EMEA region as TRUSTe, which, as you certainly know, is a leading global data privacy management company. Before that, he had a number of positions, one at OpenX, one at AOL. He also worked for High Media and Wanadoo and Orange France Telecom. Last but not least, Jan Brown is an associate director at Oxford University's Cybersecurity Research Center. He has led, and I'm sure you know him, numerous research projects on social, ethical, and legal implications of ICT, in relation also to fields of communication security and healthcare informatics. He has recently published 3 books, and he has advised the European Commission in relation to the draft regulation. So let me maybe present the topic and what we have decided. In fact, Kenneth will play the moderator for this, and we would like, after each presentation, to take a couple of questions. Of course, we can have a wider debate, but if you have a pressing question after each presentation, I think that would be certainly helpful to raise it. Let me see. Oh, I moved that. So I would like just to come back to the concept of online behavioral advertising. I think most of you know what we are talking about. It's basically tracking your or our browsing activities on the internet using some sort of devices, typically cookies, but that could be other devices. And this is taken place when you visit websites. It is a way to collect information that should infer, in fact, your interest. So, in fact, guess about your interest. And the purpose of that is indeed to enable to target more the information afterwards, the advertising that you will receive on subsequent websites. There are different ways to do that. I will not go into the technicalities of it. I don't think we have the time. But I think it is probably a first important point to make, that it's really enshrined in the ecosystem of the internet. It is in fact a way to generate revenues for companies involved in the internet, and it's also an enabler to make that most of the content on the internet is free of charge. I know this may be provocative and we may have discussions about it, but I think it's a matter of fact. The online behavioral advertising and, of course, the advertising in general on the internet is, of course, an important economic factor. When you look at the roles, the key actors in the OBA sphere, well, you have, of course, the advertisers, those who want to target the best way possible their future customers, their prospects. Those who are the publishers, so offering, in fact, space on their websites and making sure that they make the most of the space that is available on their website. And then you have those interacting between the two, the ad network providers that will create, on the basis of the information they receive when sending a cookie or another device on the terminal equipment of the users, of the internet users. They collect information, they create database, they analyze, and they provide ways to send targeted advertising to the users afterwards. There I am in the level of what is called third-party cookies. That is, in fact, that you could have also a much straightforward situation where you visit a website and the website itself, the publisher of the website, would send information or would collect information about you. In that case, it would be a first-party cookie. From a legal angle, and as you know, I'm a lawyer, I think it is important to insist on the fact that there are two directives that comes into play. And those directives have been interpreted, have been complemented by the works of the Working Party 29. I think this is important to underline because there are a number of papers that the Working Party 29 has released in that framework. One, I think, which is the most prominent is the number 171, which is in relation to OBA. There is also the review of the AESA best practice recommendation, that is the Working Party document 188. I will not go into the full details of that. That would be completely impossible in this time frame. But I think you should first distinguish the scope. If you take the General Data Protection Directive, as you all know, it is triggered when you have to process personal data. If you have to apply the e-privacy directive, in fact, the scope is larger. In that case, you can have a situation where any sort of information which is in fact stored and accessed on the equipment, the terminal equipment of users, will trigger the application of the directive, the e-privacy directive, and in fact of the famous Article 5.3. This is important because it also applies regardless of whether the company or the entity which is sending the device on the terminal equipment is processor or controller. So it's a wider scope than the directive because a general protection directive, so the 9546, in principle mainly imposes obligations on controller. There are limited obligations for processor, but this is less applicable. Well, we can discuss, I think, hours whether or not both will apply. I think in some cases the answer is certainly yes, because as soon as the information collected contains identifier, which can be often the case, well, the data controller will have to comply also with the General Data Protection Directive. What does that mean? Well, I think you all know that they will have to justify a legal ground. They will have to inform the data subjects. We will come to that in far more details. They have also to assess the data quality, the security, and also find a response to the data transfer. But I think the most important for today is really to look at the way the Article 5.3, so the one which applies under the e-privacy directive, the 2002-58, as modified in 2009, would apply. And there, the principle is that there should be a prior informed consent, which is a reference, in fact, to the principle of consent contained in the directive, in the general directive, sorry. How does that play? Well, the point, of course, is first of all to determine the role of the parties. If you look at my first slide, it is determining to identify who is playing the role of data controller. I think there's more or less no doubt that the ad network provider is going to play a role of data controller. In certain cases, and if you read the work of the WP29, the publisher will also play to some extent a role, a limited role of data controller. So some of the duties may also be imposed on them. One critical question is how do you express your consent? And there is this controversy in relation to whether it could be an opt-out, so meaning, of course, that you have to notify that you do not want to receive cookies, or it has to be an opt-in. The position currently of the WP29 is clearly that it should be an opt-in. And then there is the issue, there is the recital of the directive. I will not again go too much into the detail, but whether the browser setting would also be a response to that. So if you set your browser so as to accept cookies, that would be the indication that you have consented to receive them. The question is whether or not the setting is by default to refuse them, and in that case it's relatively obvious that the consent, the fact that you accept to receive cookies will mean an informed consent. But then the next question is, of course, if the setting is not that way, whether or not you decide to set the acceptance a different way, does that indicate also a consent? There, I think it's also important to try to find ways to make it realistic for businesses. And well, we can of course discuss that in details, but one approach that we have done in the practice is to approach that through a layer of information. So the first layer would be to actually notify the users, the web users, that they may receive cookies, and that those cookies have the purpose, in fact, to gather, to collect information, and ultimately to enable to target advertising towards those users. And then the rest of the information could come later on by clicking to a more information button, for instance, or a part linking you to a website with more information, where you would find the information which normally is required. This is, and this information you can see on the slide would include the identity of the controller, the purposes more in detail, the data recipient, the possibility to revocate the consent, the access right, etc. This proposal is something which has been put forward by the Working Party 29. The question whether technically it is always feasible, I think, is certainly to be discussed. It's not always so easy to organize. The question also is, how is the browsing experience? Because you may end up, if you try yourself and you set in your browsing, the fact that you want to be informed each time you receive a cookie. If then you visit a website, you are likely to receive many and to be blocked each time those cookies come, so that you have to click yes, I accept, or no, I don't accept. My view into that is twofold. I think, and it's a proposal that I would like to put forward, is that you would have, first of all, this system of multi-layer, so a light information in the first place, followed by more information. And the second point is to group the categories of cookies, because if you start grouping that, in principle, you will receive less of these messages, and I think ultimately it will make more sense for the users. I would like to go quickly through an initiative, which is a self-regulatory approach, which is the initiative of the European Advertising Standard Alliance, you may have heard of it, called Best Practice Recommendation on OBA. This is something that they've released in April 2011, which I think to some extent respond to what I just proposed. That is, in fact, to organize a system by which there is an information icon which is then put next to the ad, and this information enables you, when you click on it, when you click on the icon, to get more information. So the double layer I'm talking about. This is discussed by the authorities. Well, the WP29, as I said, has released a report, a paper on this initiative, stating that in fact it is an opt-out and would not be compliant. I think we should discuss that. It is also linked to the level of education of people visiting the internet. There, I believe, I would also like to discuss to what extent the public bodies have a sort of obligations to create more awareness among the users, to enable, in fact, more understanding of what the icon exactly means, so that the users can then make an informed choice in a better fashion. So to finish on this part, on this first part of the presentations, I would like to make some recommendations coming from the practice. The first one, I think, is that whenever a company is involved in OBA, well, it's certainly a recommendation to pull the resources internally. So in other words, to not only focus on, let's say, the marketing aspects, but also to involve your legal, your compliance people, your security people, your IT people, making sure that you have a comprehensive response to make sure that at the end of the day, you comply with the regulatory environment. The second point, I think, is to create a dialogue. And I'm sure that Walter will talk about that, to have a multi-stakeholder dialogue, to have interaction, and that to create actually a contractual arrangement that allocate the responsibility, that allocate the duties as data controller, as limited data controller or joint controller, to make sure that the OBA scheme does work. Design also transfer solutions, either based on standard clauses or other possible solutions. And also look, of course, that's very important, and that will be my last comment, my last recommendation, to look at the implementation from a technical point of view. You still have, of course, to be user-friendly, to be business-friendly, to make sure that you can continue to do that, but you have to do it in a secured manner, using the necessary level of control, be it encryption or others, and also making sure that you have a system by which you comply with the principle of keeping no longer the necessary, so that you have a limitation in time of the retention of the information. Thank you for your attention.
Do we have any questions from the audience? Okay, I'll act on audience behalf then, Tanguy, and ask a question. The icon is seen in a lot of places, which is a good thing. It means it's protecting the consumer, protecting brands. And you did, granted, have some recommendations there, but if you could change one technical, legal, process, what would it be to further people to adopt the icon?
I'm not sure that there is a need to change the legislation itself. For me, the most important is to create more awareness. When we drive on a road, we all have a driving license. We have, of course, followed also the traffic code. I think to some extent, and the traffic code, by the way, is organized, and well, you receive lessons, etc. I think this is a bit the way I would look at the way people should use the internet. The internet is a great source of information, but it can be also something that could scare people because they are not aware of what can be done. The next point I would like to say is that there is also a perception issue, because I would like to make sure that whenever the authorities would take more, let's say, educational paths, they should then also figure out to what extent this is important for the users. I'm not always sure that what is being put in place, and which could be somehow a deterrent for businesses, is necessarily what the users themselves want. And that, I think, I hope is answering partly at least your question.
No, totally. I tend to agree. It's based more of a collaboration between regulations and the end user, focus groups, panels, and what the public want, that consuming this
exactly.
Is where you're going to. Any questions from the floor? Come on, interactive. It's media. Okay, should we move on to number 2?
Yes. The next one is Walter. Sorry. So you want to have... Can you tell me when you want to change the...
Thank you so much, Tanguy. Can we have the next slide, by the way? The Do Not Track initiative is a highly ambitious project undertaken by the World Wide Web Consortium. But it was in fact mostly initiated from the American side of the big pond, because the FTC, not having the same authorities as, for example, the EDPS has, would like to see a way of putting online tracking, which is necessary if you want to do online behavioral advertising, to put it in the sphere of false advertising. And the idea basically is to have several goals. One goal is to allow the user to express their preferences in regard to being tracked or not to be tracked, which for the United States context would mean mostly opting out, and if the server, the website, the advertising platform, the publisher, etc., would claim to be honoring that signal and subsequently not honor that signal, then that will be effectively be false advertising. Basically, that would, by way of self-regulation for the American side of things, result in the creation of a competence via contract law for the FTC to enforce privacy online. On the European side, as Tanguy already touched upon this, we have the issue of the e-privacy directive mentioning that consent for cookies, although do not check is not only about cookies, is that it can be expressed by technical means. But in the current situation, well, at least slightly a while ago, it was mostly either you accepted cookies or not, or you had to get all sorts of non-standard plugins to manage that. And one cookie is not another cookie. Some cookies are really necessary, have nothing to do with tracking. Others have only to do with tracking. And the idea was that the browser manufacturers really wanted to standardize a way of expressing consent, non-consent. So the ambition was, on the European side of things, to have a uniform way of expressing consent for being tracked. And that's called the do not track zero signal. And whereas the opt-out model, which will be more applicable in the US side, will be the DNT1 signal. There's a third signal called DNT unset, meaning I have no idea what I want. That's all lovely in theory. In practice, we have a very multi-stakeholder group. And can we have the next slide? Thank you. And it reads like a who's who in the online ecosystem. It's the big publishers, it's the big advertising platforms, the big cloud platforms, the telcos, the browser manufacturers, of course. And can I have the next one? Some regulators, civil societies on board. Basically, W3C has ticked all the boxes for getting all the stakeholders at a table, which is wonderful, again, in theory. In practice, it means that in the current situation, the advertisers are still on a working group for the only reason to prevent the browser manufacturers and civil society to get a strong standard. And civil society is only on board to prevent the advertisers to get a weak standard. That's not a terribly productive way of approaching things. And we have had all sorts of interesting back and forth in the group. Very early on, the whole idea of DNT0, meaning I consent to being tracked, has been mostly dropped from the standard. It is part of the technical standard still, but compliance discussions about that. Oh, I should also mention that. It consists of two documents. At least that was the ambition, to have two documents. One document describing how the browser would signal to the various web platforms involved in browsing a web page what preference there was, which is a very technical matter. And the other half would be the compliance specification, which would actually describe what does it actually mean I do not want to be tracked or I don't mind being tracked. And basically, we have never agreed on hardly agreed on a definition of tracking, only recently. There was never complete agreement on what exceptions would there be or not to be. There was some agreement, but also interesting conversations for certain exceptions. For example, one exception would be that despite a user sending do not track one, meaning I do not want to be tracked, that for fraud prevention, fraud detection and security reasons, there might be some tracking involved, which might be a legitimate reason for processing the data. At some point, the Digital Advertising Alliance suggested that marketing should be one of the accepted users. That should, regardless of the tracking preference expressed, be acceptable. And when one group member asked the DA what they meant by marketing, the answer was, marketing is what fuels the economy. It's as American as apple pie, implying you un-American commie for questioning the idea of us not tracking you for marketing purposes. Well, that's my colorization of that statement. But It gives you an idea what a happy bunch this process has been in the past 2 years. And by and large, as self-regulatory approaches go, recently it has been decided to decouple the technical standard from the compliance standard, and all of a sudden we have lots of progress on the technical side. The compliance spec is mostly dead, and as such, I think Do Not Track is a utter failure. I mean, it may provide a good stepping stone to allow regulators to say, we feel this is appropriate means to express your consent to being tracked or opting out. But as self-regulatory approaches go, it is completely dead in the water. And for me, and can I have the next slide? Let's skip to the next one, actually. To me, Do Not Track is not necessarily or online tracking is not necessarily, and by extension, online behavioral advertising, is not necessarily a data protection issue. Especially when you get into the Internet of Things, where geodata gets involved, mobile web use, etc. You end up in a situation where, from a freedom of speech perspective, you need very little censorship if you have total surveillance. And by now, the net result of the current makeup of the state of play in online behavioral advertising is that several large corporate entities, for perfectly valid profit reasons, are almost omniscient about our browsing behaviors. They can measure what we read, how long it takes us, whether that nice subscription to The Economist online is actually read by us instead of us browsing The Sun online. It's inevitable to collect sensitive data, and if you have almost omniscient corporations, you also end up with a completely omniscient government. And I prefer my gods to be omniscient, but my governments I'd rather not be omniscient. And it gets back to, if you have almost complete surveillance, you do not really need any censorship anymore, as soon as people realize that anything they do. And it also touches upon other fundamental freedoms, like the freedom of assembly. And this is not entirely a Do Not Track example, but yesterday I read that the protesters in Kiev have been SMS bombed, having received SMSs saying, your mobile phone was at the protests, we know who you are. You can imagine the chilling effect of this is the result of retaining mobile data, but the next step will be that you would use similar information from people's online Twitter usage and all the other lovely social media platforms, which are all tied into this online behavioral advertising thing. And that, for me, is the really scary part about it. Online behavioral advertising as such is not that scary. It is like my old record store, when I walked in, that the guy behind the counter would know whether I would like electro or jazz or something like that. It's the idea of getting to know your customer. But in order to do so in an online environment, you have to know all your customers in all aspects of their lives. And then it becomes very vulnerable to abuse to me. And as far as the current regulatory system goes, I think we actually are able, under the current European rules, to some extent manage this. It is more the fact that we have poorly drafted our laws in the sense that it's unclear which regulator can do what at what stage. But I would call upon the regulators to get their acts together and to actually do something. Because you can't wait for Do Not Track. That will not solve the problem. It may help to do so. That was basically it, as far as I'm concerned.
Any questions from the audience? Nobody want to get into a quasi-freedom of rights debate here? No? I've got a couple. I just want to take you back a little bit. You mentioned around on the browsers that you approached a lot of the browser guys that the kind of Do Not Track initiative should be, or the technology process should be instigated at that level. Was this just theoretical, or did you approach the big brands? What was the outcome of that? Could you elaborate a little bit more on that?
Actually, I never approached anyone. The big brands got together because because they foresaw a situation in which every browser would have its own way of expressing opt-in or opt-out, which I'd rather not have. And I must also say, especially Microsoft and Apple, and of course Mozilla, but Mozilla has a long-standing tradition to be very pro-privacy. They have done an outstanding thing so far in this process in making sure that whatever the outcome was, that it was meaningful, implementable, and useful and trustworthy. That's in that sense, I think all three of them, and including Apple and Microsoft, which have not always been on the best behavior when it comes to privacy, really must be complemented in this process. Does that answer your question?
Yeah, very much so. Thank you. Anyone else? Sorry, Stuart, could you just wait for the microphone and then everybody can hear?
Thank you.
Fantastic.
Stuart Dresner from Privacy Laws and Business. Hello. And my question is that with your representing privacy from a European perspective on the World Wide Web Consortium and Do Not Track, is there any difference between your views from a European perspective and that of Peter Swire and Justin Brookman, who's representing the pro-privacy lobby from on the American side?
Peter Swire no longer is in the group.
I know, but...
He was a chair.
Yeah.
Well, there clearly is much more involvement from the American civil society groups. By and large, they take a more consumer rights-oriented approach, whereas my position and that of other Europeans is I'm not a consumer per se, I am also a citizen and a human being. But by and large, that does not necessarily result in different outcomes. It's also very interesting to see that the European approach, which is not really adopted very much in the standard so far, about the controller processor model, measures much better with the underlying technical HTTP protocols of the web than the approach advocated by the FTC with first and third party and other complications. I think if you would really ask also the technical people from some of the companies that are not really necessarily pushing for very strong standards, they would agree that it would actually be much easier to just implement the European model in this standard than to go the FTC way. Does that answer your question, by the way?
Your last point's fascinating about you saying American companies think that the EU approach is better than the FTC approach. That's
some technical architects from some American companies, an example would be Roy Fielding from Adobe Systems. He hates the e-privacy directive, but by and large, he quite likes the controller processor model. At least he doesn't say it out loud, but you can read it between the lines. He'd much rather stick it to such a model because it fits with HTTP how it works under the hood.
Okay, thank you.
Hi, Kasia Szymilewicz, Panoptykon Foundation, Poland. Just two quick insights from our experience in Poland, where we did manage to convince government to go for opt-in scenario with regard to cookies, but at the same time, across the market, so to say, we agreed that it would be ridiculous to demand explicit consent from the client, the customer, the citizen, you call it, every time we are confronted with an ad. So we thought that the browser setting would be an obvious answer, but at the same time we felt we are trapped without having browsers cooperate the way that you described it was planned in the W3C group. I mean now how we deal with the default setting in the browser. If the default setting is yes, I agree to accepting cookies, then we cannot really have the debate. We would have to convince all the three big companies to reset the default to either signal I haven't decided or no, and only then we can really talk about explicit consent, and I believe we can all agree on that point. But then because the browsers are not regulated by the EU, not even less by the Polish government, we cannot force them to cooperate with this new legislation, which became void in effect. I'm just showing you this to say that any implementation of the privacy directive really fails without cooperation of the browsers, private companies.
Actually, the mobile Safari on your iPhone, if you happen to have an iPhone, has Do Not Track 1, meaning I opt out on by default.
Right, so it's a good example of the practice that we would like to see, but my question would be maybe how we could think of regulating, whether at all, browsers directly to sort of force that default settings and not rely on self-regulation, because my understanding is that it has failed. And another issue you might like to consider, I would just finish and let you comment. I mean everybody, if you like, of course, whether we should not be trapped in a cookie debate and rather think of tracking in more general terms, because if we keep talking about cookies, whatever we invent, it will be, well, in a minute it will be not relevant at all because the business will move to another tracking devices, so whether we don't lose time at all now discussing cookies. Thank you.
On the bit on cookies, yes, I fully agree. And that's one of the great things about Do Not Track. There are great things in it. It does not focus on cookies. It also includes beacons, browser fingerprinting, basically the idea of gathering behavior across different contexts or different sites of users. So that's, in a way, industry is kind of ahead of the e-privacy directive in that. To get back on your remark about default browser settings, by and large, the browser makers are very willing to put on their default privacy settings side because they are competing on privacy right now. They consider it a competitive advantage to show to the user, if I use this browser I am bringing to the market, you will be more safe online than with another brand. The big fight in the Do Not Track group was basically about Microsoft turning on Do Not Track by default in Internet Explorer 10. And the end result was that the compromise was that the setting would be unset by default, which subsequently Microsoft, which in a very lovely way said, well, as soon as you activate Internet Explorer 10, you get a dialog popping up saying you could set it on by default, and most users actually do for new installments. So, but when it gets to the need for regulatory action, it's not in that area. The need for regulatory action is on stepping in, because regardless of how you feel about the e-privacy directive, tracking data is processing personal data, and this is personal data that encompasses wide swaths of people's lives. Even the least hawkish DPA, or the almost least hawkish DPA in Europe, the British, agree that that does not fit a legitimate purpose to survey people's reading habits online all the time across extremely wide range of contexts. And that's the bit where the regulatory action is needed. I would say any publisher who uses advertisement platforms, from my perspective, and I'm disagreeing here with Tanguy, is a controller who chooses to use a certain advertisement platform and subsequently should have data processing agreements with that advertising platform and subsequently to the parties behind that, and should also take care that that's not exported outside the European Union, which means almost any website nowadays should have a data processing agreement with Google for Google Analytics or whatever analytics platform you're using. Those are almost never there. The DPAs could enforce that right now and here. They don't.
Thanks for that, Walter. Can we just have one more question, because the lady's been waiting, then we need to move on this.
Yes.
There will be a debate at the end, so we can bring this up again.
Yes, thank you. My name is Janneke Sloetjes. I work for Dutch NGO Bits of Freedom. And I have a question relating to citizens' rights. It was just touched upon, and Walter mentioned it again, that the information is very sensitive. And I was wondering who in this panel has information about actual requests made by law enforcement agencies to companies that compile tracking data and that compile profiling data. I mean, do such requests take place? How often do they take place? And is there already something in place to ensure transparency in case that does take place? I'm really curious to know if you have this information.
I think that question is yours, Kenneth.
No, we don't have information on that from a European angle. No.
I have a slide that is relevant.
Yes, Ian's going to touch on this in his point. And with that, we'll move on. Ready?
Okay. Yep. Oh, could you flip to the other slide first, because it's more relevant to that direct question.
Okay.
So yes,
do you want to
yes.
move that for you?
That was a good question because it teed up my presentation nicely. Yeah. I'm going to talk just briefly. I've just got a couple of slides about the way that tracking technology in general and technology specifically that's being used to profile individual users and then show them targeted advertising is evolving. I think one of the, regardless of the broader political debates about the Snowden leaks, I think one very helpful thing that those have given us for discussions like this is much more concrete information about what is going on, at least from one country's signals intelligence agency. So you may well have seen this slide, which was published by the Washington Post last month, looking at how the NSA had actually been using the tracking techniques including from cookies, and feeding that into their own surveillance system. So in particular, this slide and related slides that were published by the Washington Post mentioned particular Google cookies that were being set for targeted advertising. I'm sure it's not only Google's systems that have been targeted in this way. There are particular preference cookies that Google sets in people's browsers who visit not just the main Google sites directly themselves, but also other sites that have Google components like +1 and all of the other things that Google contributes to other sites. A quote from the documents that the Washington Post published was that the National Security Agency's Special Source Operations Team shares logins, cookies, and Google Pref ID tags with their Tailored Access Operations Division, so that's the part of the NSA that then goes and breaks into systems that they've identified to be of interest to their customers within the US government, and also they share that information with GCHQ, which is their British equivalent. We also know from another leak reported in The Guardian that the NSA was using double-click cookies to try to identify Tor users, which was the anonymous web browsing and other online activity software that it seems NSA actually had found very difficult to crack, and so trying to then look at the cookies on the browsers of the individuals that were using Tor was one way that they tried to get access to that. So that's a first step. I agree absolutely. Your question deserves lots more data, and I think it would be very useful to have more data to have that more concrete discussion. We also know from these set of slides that the NSA was also getting access to the smartphone location data that was being supplied by smartphone apps that were using online behavioral advertising tools. Of course, one of the bits of information that's used in some OBA systems is the current location of the user, because it means you can show the user then ads targeted to their current location, which is very useful for showing location-based advertising clearly. That was also going into the NSA databases, so it would let them more closely monitor the location of users that they were interested in, and it was also enabling the NSA to better geolocate IP address blocks, because they could see what IP addresses smartphones had been allocated by their provider, and then link those to geolocation coming from GPS and other sources of location in the smartphone. A couple of interesting things also relevant to some of the points that Walter was making. One way that the companies setting the cookies and so on that are responsible for those tracking systems, one way that they can deal with this concern that some users have about being tracked by advertisers turns into potentially being tracked by governments is to encrypt the data flows as they go between the end user device and the publishers. That would stop intelligence agencies that are picking up this kind of data directly from the internet traffic flows themselves, which we know NSA and GCHQ and others have been doing. It doesn't, though, stop intelligence agencies that have legal powers to go to the companies and compel the production of the data. And actually, in these set of documents, that seems to be the way that NSA was acquiring this data. They were going to Google and using the US Foreign Intelligence Surveillance Act to compel Google to produce information, including these details, about people, users that met certain broad criteria that NSA had the legal powers to compel that information on. So that encryption across the internet will stop some of these kinds of tracking attacks, but not others. And that's a very broadly applicable point. If a company is tracking a set of individuals in order to be able to show them targeted advertising, then whichever jurisdiction that company is in, holding that data, it is data that is of interest to law enforcement agencies, potentially into intelligence agencies, and many countries, again, not just the United States, do have those broad powers for intelligence and law enforcement agencies to compel the production of data in that way. And it links in particular with one very specific point that Walter mentioned about the do not track discussion, which was, if you are following it, you'll know some companies, particularly the advertisers, were arguing in effect DNT should mean do not target. In other words, they should still be allowed to build the profile, but then they wouldn't show you targeted adverts based on the profile, whereas others, particularly civil society groups and privacy advocates and regulators, European privacy regulators have said, no, it's do not collect. It's do not collect the data in the first place that then allows the profiling of the user. And clearly that has an important link to this debate about which other parties, whether government or otherwise, might get access to this kind of data. Could you go back to my other slide? Thanks. So having said all of that, I wanted to talk just a little bit about the way that OBA tools and techniques could evolve in future, particularly given the focus in the proposed regulation about privacy by design. Are there ways that technologists can build systems that still allow adverts to be shown to users based on some kind of profiling information about their interests and other matters, but without necessarily supplying that data to first-party websites that they're dealing with beyond the direct interactions with the first-party websites and these third-party publishing networks and so on that are building the much broader profile. So this slide is just showing some research I did with colleagues a couple of years ago. I'm not trying to sell this to you. This is computer science research rather than a finished system that I'm hoping. We haven't patented it. We don't have a startup. I'm not hoping Microsoft will buy it as I walk out of the door.
Let's talk after.
just to illustrate that there are options in designing the technology. Cookies have become, there are all sorts of cookies, problems with cookies today as a mechanism for doing OBA because of the controversies we've seen over many years of them, the fact that now many users block them, whether through preference setting in their browser or using plugins to block them. Of course, on the other side, the advertisers would like very much to be able to have a picture of users as they move across all of the different devices that they browse on day to day. So people have moved from just having the desktop PC to the laptop, the smartphone, the tablet, the gaming console, and so on. And clearly, if you're an advertiser that wants to show very targeted adverts, you would really ideally like to be able to watch your users as they move across all of those different technologies. One way of doing that would be to have sort of super cookies, if you like, or synchronizing cookies or similar information across a user's platform, or using other types of information, or persuading people to log in even to let you to monitor right across. What we suggested instead was a much more decentralized approach. So saying smartphones obviously have the ability to store, they do store lots of data generated by users' activities. They can do limited computation, obviously not big data processing of the types that people like Google will do, but limited profiling based on your own activities on your own smartphone. You could keep that profile on the smartphone under your direct control. That would never be sent to a third party. In the meantime, an advertising network could send lots of adverts to your phone, not just ones based on what the network knew about your interests, but a very broad range of adverts, which then software running on your phone would pick out adverts based on that locally held and locally controlled profile that it thought was relevant to your interests without revealing your interests to the advertiser. We even suggested you could do the location-targeted adverts using the fact that Wi-Fi towers and mobile phone base stations can broadcast data. So one of the things that they could broadcast with this kind of system very efficiently is a whole range of locally targeted adverts, which again, your phone, seeing one that your phone thinks might be of interest to you, could then show it in one of the web page publishing spots that the publisher had left by agreement with the advertising company. And we also said there are techniques you can use to send the reports about which adverts have been viewed by the customer, which of course is important to the advertiser to get that feedback on click-throughs and so on. You could send that data back to the advertiser, but without it being linkable to the user that it came from. So the advertiser gets the aggregate feedback data on how many people are looking at and interacting with, clicking through the advert, but without that report being linkable by them back to the customer. So this is just one of a number of ideas that computer scientists have proposed as a way that companies develop advertising technology in future. You could have a much stronger focus on privacy by design in the technology itself. Thank you.
Thank you, Ian. Any questions around that? One brave man, Stuart again, thank you. She's coming.
So yeah, Stuart Dresner from Privacy Laws and Business. Ian Bratton, I thought that your model for a privacy-friendly targeted advertising looks very good, and I want to know what you thought of a session, the XQuick model, which we heard about yesterday. This is a privacy-friendly search engine based in the Netherlands that sort of fulfills, I think, the same objectives. I want to know what you thought about that as a working system.
Yeah, I think XQuick and some of the others, I think Scroogle is similar.
What was the second one?
Scroogle.
Scroogle.
Scroogle, I think, is a similar kind of idea. I think that's a positive step. I personally use DuckDuckGo rather than Google because I prefer DuckDuckGo's privacy policies, and they collect less data and so on. That said, as a technological set of protections, clearly if I don't know in great detail what XQuick does, but what I understand it does, and Stuart, tell me if I'm wrong, is effectively they are doing some of what I was discussing that your phone might do themselves, but separating or insulating you from the advertiser, so that XQuick might have some information about what you're doing, but they protect it under Dutch law and their policies and delete a lot of it rather than passing it on to the third-party networks. Is that right?
That's what I understand.
Yeah, exactly.
You have to speak to them directly, exactly what they do.
Exactly, and I think that's a step forward, but clearly that company is subject to the laws of the Netherlands. If Dutch government agencies that have laws to compel data in investigations went to them, they could do that. The data exists still outside the direct control of the user. That's the benefit from the user control perspective of keeping the data always on the phone. If you're fully in control of the phone yourself, then you would know where that profile was and who it had gone to. And that then addresses the broader freedom of not just privacy, but freedom of expression, association, and so on, issues that Walter was mentioning.
Okay, thank you.
Just time for one more, please. I'm conscious about it, and we've got to get Anna on next.
Wendy Monco, University of Dundee. A number of the panel have mentioned about users and being tracked across different devices, but I'd be interested to hear briefly the panel's thoughts on multiple users, so families using a single device, and the kind of behavioural tracking and the kind of offers you get as an adult when maybe you've got teenage kids or younger kids.
Yeah, that's a very good point, Wendy. Obviously, with personal computers more than laptops and especially smartphones, you often have a number of different people using them. Might be very, very embarrassing for different family members. Sometimes one of my former PhD students did some really interesting research with how HIV patients use the internet to get health-related information and manage their condition. And many of those people would not use their home PC for precisely that reason, that they felt less internet savvy, they weren't sure that they could delete their history and cookies and so on, and they hadn't necessarily disclosed their HIV status to all of their family, so they were really concerned about that. So I agree, big issue. There have been some interesting technologies developed which claim to be able to differentiate on the one device between different users based on their browsing patterns. How far that would deal with the kind of concerns I was just describing, I think, is an open question.
Quick one more, Cliff.
Yeah, quick one. In the context of advertising platforms, that is more of a mix-up as soon as you get to the social networks, even with multiple users on the same device. People log on to Facebook, and subsequently Facebook, well, even if you're not logged in, but Facebook will, via all the like buttons, track your reading behavior online, and as soon as you're logged onto Facebook on that particular device, that particular family member will be connected to that particular browser behavior. So there's, even at the same device, there will be a certain level of individualization. At the other hand, we know very little because most of the parties involved in these practices are not willing to disclose their practices anyway. In the case of Facebook, we know a bit, but for other parties, we know much less.
Okay, let's move on to Anna. I'm going to tie it back into OBA now.
Yes. Thank you. So the last presentation today and another one looking into the future. There were already 2 panels yesterday, I think, which discussed the current status of the reform. So I will not go into any details there, just to say, as you are all aware, this is not yet a done deal. And another caveat, what I will be discussing here today is based essentially on the texts voted in the LIBE committee of the European Parliament last October. So this is not yet even the formal position of the entire Parliament in first reading, although of course it is possible that it will become that. But there is also another text under discussion in the Council, and the entire negotiations process still needs to begin. So I will try to focus on, just say a few things about those elements or features of the proposed regulation which I believe are most relevant to OBA, and which in my mind also reflect a certain trend, or at least the intention to clarify that the data protection framework, the rules, should be applicable in this context, and that the issue is indeed much broader than a simple use of cookies or similar devices, but that it is really all about tracking of user behavior online over time. Next slide, please. So, firstly, what the proposed regulation does, it clarifies, the text clarifies that the rules should also be applicable to non-EU based controllers or processors. For instance, in cases where they are monitoring data subjects in the EU. And there is a clarification that monitoring involves, among other things, the tracking and the use of profiles, in particular for analyzing or predicting an individual's preferences, behaviors, and attitudes. Combined with the fact that the material scope, so the definition of personal data, remains unchanged, and so is still quite broad, and some further clarifications, which I quote here in a recital, it seems to me that there is a clear trend towards accepting that a lot of the processing that is taking place in the context of OBA actually should fall under the rules, even when it is being done by non-EU based companies. Next one, please. We do have some new provisions in the regulation which go beyond what is in the current directive, and one of them is a new definition of profiling. We see that, by the way, both in the LIBE text, but also in the Council draft, and these are things which are actually being discussed right now in the DAPIC's working party. The profiling would be subject to a set of specific rules. And the LIBE text essentially seems to distinguish between two types of...
Thank you.
So very quickly, two types of profiling. One I call a regular one, which would be subject to the normal rules, so ordinary legal grounds, normal consent, legitimate interest with balance of interest, etc. And there would be a right to object, provided that sufficiently highly visible information is provided to the user. But there is also a second, what I call a qualified instance of profiling, which would be subject to stricter rules. And this is the profiling which would lead to legal effects for the data subject, or which would similarly significantly affect the interests, rights, or freedoms of data subjects. And here we would have to deal with a restricted list of legal grounds possible, each time accompanied by suitable safeguards. There is also a prohibition on discrimination on the basis of so-called sensitive data, so data related to health, for instance. And the additional safeguards which I mentioned are meant to include, for instance, the right to a human assessment, and also the right to obtain explanation of any decisions that were taken on this basis. Now, of course, the big question is which kinds of or instances of profiling would be subject to these stricter rules. And next one, please. there is a hint in one of the new recitals added recently in Liebe that profiling based solely on the processing of pseudonymous data should be presumed not to significantly affect data subjects. Of course, this is still an open question to what extent this would be relevant to all instances of OBA. But this recital, combined with the previous provision which I mentioned, is often interpreted as meaning that there is a certain flexibility built into the new rules for possibly at least some instances of OBA, to the extent they would be based solely on pseudonymous data. And just very quickly, next one please, really the last slide, just to signal some other elements of the new, of the proposed regulation which could be relevant. So it was already mentioned that we are dealing here with a very complex relationships, contractual relationships between the different actors, and complicated business models, publishers, ad networks, analytics companies, social networks. It is sometimes quite tricky to distinguish between the controllers, the processors, and to assign the responsibilities accordingly. Now, in the future, if the regulation is adopted, there is much more emphasis actually on clarifying these roles properly. And there are specific rules recognizing also instances where there are joint controllers, so various entities together responsible for setting the purposes and the means for processing of data. There is also an obligation, there would be an obligation on such joint controllers to set out an explicit arrangement clarifying what their respective responsibilities would be. So certainly the regulation would force, I think, many of the actors to think again about what their specific roles in these models are and what the related responsibilities and liabilities should be. This is, of course, all linked to the principle of accountability and the emphasis on the actual controllers, but also processors, and the measures they should be taking to ensure the security of the data, to ensure that the rights of data subjects are compliant with, but also obligations related to maintaining documentation, to data protection by design, data protection by default. All those elements would become mandatory not only for controllers, but in most instances also for data processors, which inevitably would also impact many of the actors in the OBA landscape. I will leave it at that, I think, but I would just want to make two final remarks. First of all, if and when the regulation comes into force, as was mentioned before, there are also rules in Article 5 of the e-privacy directive, and these rules will not immediately be impacted or affected by the entry into force of the regulation. There is an intention or a commitment by the Commission to revise the e-privacy directive in due course to align its provisions with the future regulation, but of course that will take time, and in the immediate future we will still have to or there will be still the need to comply with the e-privacy directive as it stands now. And final remark, there may be some other rules and regulations in different domains than data protection and privacy that may be relevant in the OBA context. For instance, the general rules on consumer protection or unfair commercial practices, where there is also quite often an increasing tendency to think that there is clearly a need for more transparency and clear and meaningful information to users, with a specific focus on presenting certain services and goods as free, while in fact the consumer is maybe not paying for them with money, but in fact they are paying with their personal information. Thank you, and I will be happy to answer.
Anna, thank you. I'm going to throw it open and Tanguy. Yeah.
Yes. I just would like to make a couple of remarks. One of them is that I think what we have said to some extent went beyond OBA. And I would like to avoid confusion with what should be resolved, I think, by public bodies and what needs to be addressed by the private sector. If you think about the tracking by the NSA, well, in my view, it is something that should lead to an international treaty it should be resolved at the level of public sector and not by the private sector, which in fact is caught in the middle of that. They have no means to avoid. The second point I would like to make is that there was a remark about browser setting. I wouldn't like a sort of a one-fits-all solution. I think the private sector should always be entitled, well, they have to read the law, they have to understand how they can be compliant, they have to know the rules and make sure that they apply them, but they should not be imposed any technological means to achieve them. In any event, tomorrow, who knows whether there will be another device than a browser or any other ways to track information or to provide information. I think we need to find a response that is technologically, of course, fit and suitable, but that should be left at the choice of the private sector, in my view.
I think very well wrapped up there, Tanguy. And just want to throw it out to the audience. Any questions from anything today? Open forum.
Yeah, this is Khurram Choktai from Pakistan. I am a technology law attorney and a lecturer at law school. My question is the right to be forgotten. I'm just asking, what is the possibility of extension of right to be forgotten to the OBA profiling? Whether there is a possibility or how? OBA profiling.
Well, I guess it's a question to me. I don't have a straight answer for you. And one reason is because the discussions on the reform are not yet over. And the right to be forgotten seems to be one of the most contentious elements of the Commission proposal. So I can just tell you that, for instance, in the LIBE text that I was commenting on, the right to be forgotten is no longer there as such. It has been merged and assimilated into the article dealing with the right to erasure of data, which to some extent already existed so far. But I would say that certainly the discussions are not yet over, so we will have to see whether and in what form this right emerges out of the whole process. That's one thing, and secondly, in what instances it would then be applicable and enforceable technically. Thank you.
Any OBA-related questions?
If there isn't, can I make a point?
Yeah.
I would say on Tanguy's last point, I disagree actually. I don't think businesses can say, we are going to build this system of profiling over here, and if people don't like that being used by intelligence agencies, then fix that with the intelligence agencies. I think that's hopeful/naive in the extreme to think that that will deal with the problem. I think businesses that are collecting data about people, building profiles of people, have to take some responsibility if that data is then used for other purposes.
Just then kind of leading on from that, you know, the ad tech ecosystem is quite complicated, and this is what we are talking about here. Who is responsible for that? What's my question to you here? Who would you say? Is it the publisher, ad networks, the browser, agencies, the advertiser directs? Because everybody, from my experience, passes the buck a little bit. They kind of say, it's not my responsibility. Yeah. It's that person, it's that person. So this panel here, who would you attribute the blame at if you wanted to? And there's no publishers or guys here, so we can speak freely.
But I don't want to be contentious, but I think if a company looks at the law, applies the rules to the maximum extent possible, organize an opt-in, and at the end of the day, nevertheless, it is accessible by secret services, I wonder if that company can go beyond what they have done. That's my concern. I'm not saying that even as a citizen, I think we have to be aware of that, and we have to be informed and make, the right decisions. But beyond that, if the law is set and you comply with it, I don't think we can go beyond that.
Yeah, Paul Bernal from the University of East Anglia. I have a comment relating to both of those last two. There's another aspect to the online tracking thing, which is the normative aspect, that we're asking ourselves in the privacy field, is it okay for us to be under surveillance all the time? And we're not, one of the roles of the online advertising industry is to make it seem that it is okay to be tracked, just as long as it's for a good purpose. can the advertising industry not see that this is potentially something they should be considering, that they have an effect on the mentality of everybody as well as an effect on the technical position? Some of us don't want to be watched as a matter of fundamental right rather than as a matter of particular practice or particular impact.
I'm actually going to say something nice about the advertisement industry. Basically, it's not unlike the copyright debate and all the other debates. The advertising industry is doing what they have always been doing, namely advertising marketing. And they are exploiting the new and almost endless possibilities technology provide us. The thing that the advertisement industry is maybe overly slow in waking up to, that these new possibilities also have a very dark side in many respects. And I'm not only concerned about intelligence services, I'm also concerned about the quality of data and the reuse of data in entirely different contexts and how that can ruin people's lives. And I have, to some extent, sympathy with advertisers who feel like, well, I'm an advertiser, and my father was an advertiser, my grandfather, I'm doing the same thing, but it's just in the digital environment and I'm exploiting new and wonderful possibilities. And all of a sudden you're bothering me with fundamental human rights. Why is that? Well, because there are much wider implications, and I think ultimately the advertising industry and other industries will have to come to terms with that and maybe refrain from using certain techniques because there are downsides they are just not realizing because they were never part of their lives before.
Okay, and if there's no further questions, I think we're going to leave it there. Thanks to all the panel. Very enlightening and informative. Thank you.